Tjenashkamadan, Madame la Présidente, qui est Nanashkama Audette Inototasiwa, le peuple Anishinaabe, un peuple qui m'accueille.
A people that have welcomed me since 2021. I asked them for permission if I could stay on their territory until I'm 75, if my health permits, as a senator. However, it's a land, a space shared with many cultures, rich with history, that have mobilized, that have their own protocol. Thank you very much to the Anishinaabe people. Dear colleagues, I rise today to speak to you about Bill S-2, an act to amend the Indian Act, new registration fees. This is the first time a bill is in place to amend the Indian Act and have it sponsored by an Indigenous minister as well as a Innu senator from Quebec. So we're making history. And I hope we will be able to work together for many years yet. I hope my daughters will hear that. I will try to give you time to answer questions. If I run out of time, I apologize in advance. But you'll understand that I might not have all the answers to your questions. However, various ministers, departments, and the cabinet are carefully listening to the exchanges that I hope we will have. I come before you with a great deal of determination. This isn't just a bill. It's not just a text. It's the beginning of an answer, a response to decades of injustice for men, for women who continue to experience it. This bill intends to grant new rights to registration in response to the challenge to certain provisions of this archaic law deemed discriminatory under the Canadian Charter of Rights and Freedoms in the case of Nicholas versus Canada. People affected by enfranchisement took Canada to the Supreme Court of British Columbia. The Nicholas civil suit was filed in June 2021. The plaintiffs, many of whom are descendants of people who were enfranchised by colonial policy, are patiently waiting for justice to be done. To these people I say, I hear you. I tell Catherine and her whole family, I hear you and I understand your struggle. I understand. And to my dear colleagues, my fellow senators, those who are here in this chamber, which I think is important, I must tell you that in this case, the Attorney General of Canada, just a few days ago, admitted that this law being challenged unjustifiably violates Section 15(1) of the Charter of Rights and Freedoms. It's rare to hear that. This type of concession is quite exceptional. Right now, the judge is looking at suspending the declaration of invalidity, which would give Parliament time to pass Bill S-2. This means that the court is waiting to see if we, as legislators, are going to act. So you'll understand why passing this bill is not just symbolic. It is necessary. It's important to act now. And we can't miss this opportunity to harmonize legislation with justice, equality, and the Charter. We must make sure that legislation no longer separates families and deprives them of their rights and their entitlement to their identity. We need to show these people who have waited for so long that their patience and perseverance were worth it. Bill S-2 is a chance to correct this painful injustice brought to light by the Nicholas case. And who's it for? And why? I will tell you a bit about the why, if the bill passes. For the section on entitlements, and this is important, for my Innu mother, it was very painful, and we're still experiencing the consequences. It would ensure that people with a family history of enfranchisement would be treated the same as those who don't. And we're talking about this being under the Indian Act. When it comes to individual deregistration on application, it would allow individuals who want to have their name removed from the Indian register to apply to be deregistered. What does that mean? Some of us are fighting to go into the register. But let's say I fall in love with a person who's a member of the Navajo people in the United States. I can't be a citizen in their government because they don't accept double membership under the Indian Act. So, currently, I am unable to deregister from the Indian Act and move my family to live over there. This bill would allow for deregistration in order to become part of another nation. And if we divorce or there's a death or whatever reason, I would come back to my land and I could be automatically re-registered. As for the section on loss of natal band membership, it's a very paternalistic law. Women who married an Indian, and I'm using the language of the Act, from another band, from another reserve, another community, was, without her consent, automatically transferred to the husband's band. That means that women and their direct descendants, after a death, a divorce, or separation, had to stay in that band. This section would finally allow women and children and their descendants, if they want, of course, if they want, to go back to their natal band. And another section for removing obsolete and offensive terms. It would remove obsolete references to mentally incompetent Indians. Of course, I can't remain silent.
The perfect bill. I would lie to myself, first of all, but also to my mom and many people that I walk beside. For too long, Indigenous women, First Nation women, fought. They went in court, they challenged in court, but with no money, with no support. They even have to fight against their own brothers or fathers or people from their own nation. The sad part is when the court challenge program was ended. It was very tough, very hard. So I do live that frustration with them all the time. And we always have to wait for a court decision to do some change within the Indian Act. Why? Alors, j'aimerais ça vous dire une section.
So, I want to talk to you about a section that a judge put in his decision, Deschenaux versus Canada. It's a paragraph, section 235. It does not, however, exempt Parliament from taking the appropriate measures to identify and settle all other discriminatory situations that may arise from the issue identified, whether they're based on sex or another prohibited ground, in accordance with its constitutional obligation to ensure that the laws respect the rights enshrined in the Canadian Charter. That was in 2015. Not in 1860, 2015. I come from a nomadic people. We've existed for millennia, the Innu. And in our protocols, our laws, our rules, our codes, our ways of being, There was a time when men and women had very clear roles. Our relationship to the land and protocols and laws was sacred. But from one day to the next, legislation came in without informed consent. Nobody asked for my opinion or that of my great-grandmother. It was the 1857 Act for the Gradual Elimination of Savages. And that hurt. And it was issued from a colonialist tradition. Later on, there was also the very open goal for assimilation. And a former official in 1920, Duncan Campbell Scott, who worked for Indian Affairs, clearly stated, our objective is to continue until there is not a single Indian in Canada that has not been absorbed into the body politic. And there is no Indian question and no Indian department. That is the whole object of this bill. End quote. So you'll understand that what we're facing are colonial roots still embedded in policy. They're still in the legislation. Bill S-2, therefore, continues the work begun by many people in various bills, including C-31, C-3, and S-2. Some of us certainly remember the repatriation of the 1982 Constitution. For women, who we called Indian women, it became an important tool because we were talking about the right to equality in the Charter. It's what encouraged the government to introduce C-31, which allowed many women to regain their status after marrying a Quebecer or someone from Thunder Bay or a non-Indian.
But Canadians and Quebecers were welcomed into 85. They would be given an Indian status. These were considered acquired rights. We're still in 2025. We're still in 2025 today. So this brings us a way of seeing things that are complex, but we understand it. We're living through it. It's a two-tier status.
85. And plus, before 85, if I was giving birth, I wasn't asked, who is the father of my children? But since 85, I am asked to say who is the father. What about if it's a rape or incest, or the father died, or I'm in a violent situation, or I just don't want to give the name? Well, Ottawa will presume that the dad is not status Indian. Then again, if I'm a 6-2, the cutoff generation, my baby will not be recognized. So you know I'm from Schefferville, up north, train, plane. The community will be allowed to refuse services to my children. But what if a woman here at the hospital comes and the person who welcomed the woman and say, by the way, before I give you services, I need to know who is the father of your children. Je pense pas que ça passerait.
I don't think that would work. And yet for us, that's still the case. Such stories, such wounds, such scars are something we bear every single day. And we also bear them because the government was negotiating behind the scenes with the chiefs, mainly men. They were saying, we're going to let you create your own code of belonging. And the government will approve it. So that was yet another form of discrimination. Who was an Indian, who wasn't an Indian. Power was granted, but it was restrictive. This power was awarded to the bands, which led Sharon McIver to mobilizing. Sharon was from a BC First Nation, and she challenged certain provisions of the Indian Act. She compared women and children to Indigenous men in her challenge. And in 2007, the Supreme Court of BC ruled in her favor, finding discrimination on the basis of sex. At the BC Court of Appeal, however, where the decision was challenged in 2009, and by then I had my 5 children, I should say, the BC Court of Appeal then handed down a more restrictive decision, as if the discrimination had only begun in 1951. That was not the case. So that led to C3 in 2011, where Canada had to respond to that court ruling, and that led to a debate on C3, which was adopted, which passed. Some of you may know my style already. When I was an activist, I still am, but my style has changed somewhat at 53. When I saw the press release,
Trust for All Indians. Et au ministère des Affaires indiennes, la personne.
and at the Indian and Northern Affairs,
I speak to my father in Trust for All Indians. Tout ça pour leur faire comprendre qu'il y a une décision de cour qui est importante.
the point was to make them understand that a court ruling was very important for hundreds of women and children like me, including me. I had a long list. I wanted to know what the impact was. Many women would be affected. The call back was easy. The answers to all my questions were no, no, no. 6-1, 6-2 isn't changed. I said, okay, I'm on my way. I'm going to put on my sneakers and walk to Ottawa to denounce the Indian Act. On May 4th, 2010, along with other women, we set off from Wendake and walked to Ottawa to hear the debates in the month of June held in the other place. There was a lot of pressure, not only inside but outside of Parliament. I'd like to say thank you, however, to Honourable Chuck Straw, wherever he is now, Minister of Indian Affairs at the time. I'd like to thank him. It wasn't easy. You answered our calls every single day during that walk to Ottawa, and luckily the bill was adopted, but once again, with a too restricted approach, even though there had been the opportunity to make major changes. We come to 2019. Once again, S-3, and the work of our honourable colleague Vivian Dick, who will defend this bill and try to move it forward as much as possible. But once again, it was fairly restricted. At the same time, however, the justice in the Deschenaux case, Justice Mass, said herself in 2015 that several sections of the Indian Act were unconstitutional. They violated Section 15 of the Canadian Charter of Rights and Freedoms. They maintained sexist distinctions between the descendants of men and women who had lost their status, and they introduced discrimination based on family lineage. Thank you, Mr. Deschenaux, Mr. Dubé, and Ms. Yantha, who challenged the law in the courts. In 2020, a final report to Parliament on the review of Bill S-3 acknowledged also that residual inequities remained in the Indian Act. Thank you to our colleagues here at APA, who in June 2022 presented an interim report that concluded, once again, registration inequities persist and continue to adversely affect First Nation women and their descendants. June 2025, 160 years later, I'm here before you in the hope that this long discrimination imposed on us finally will be eliminated. We often hear that we're all equal before the law, but in reality, our mothers, our sisters, and their children continue to be treated differently. And for me, that is not the meaning of equality. That is the meaning of gender-based discrimination. Discrimination because I'm a woman, and in the law, under the Interact, Section 6.1 or 6.2, I'm still facing discrimination. So the impact is direct. With regard to status, yes, but it was also the initial impact of breaking the ties between our culture, our identity, and our language, and also to be able to take part in the democratic life of my nation. I do not have that right. Every time the government sees a court ruling, it will make a change on a case-by-case basis.
We'll wait. We'll see. Alors qu'on a tous les outils juridiques.
And yet we have all the legal tools we need to make lasting change. I come from a culture where words are law, narratives are law, and here as well, narratives are important, stories important. The story of Catherine Fournier, who accepted to be here today, her story is affected by this law. Her grandfather, Morris Sanderson, was one of the survivors of residential schools, like many other Indigenous people. And due to the provisions of the Indian Act, he could not purchase a home or land. He could not vote. He needed to be enfranchised first. But in 1922, having experienced these aggressions, assaults in the residential school, he made a difficult decision. He decided that everyone in his family would be enfranchised, his wife and their children. I don't know if they gave their permission, but that's how it worked at the time. And with the arrival of C-85, she and her mother tried to re-register, to register again, but realized that inequities still exist. So she decided, along with her mother, to join the challenge, the charter challenge of the Nicholas ruling as a plaintiff. And unfortunately, her mother, Catherine's mother, Edith, has passed away, so only her mother, Catherine, is continuing. But this explains her motivation. I would do it for my mother as well. I am doing this for my mother. It's important to be able to say who you are, and for children to be able to say as well who they are. Registering in one's band is above all about reforging ties with one's culture, identity, and language. There's also the story of Nadia, Son Nangwas, and her younger brother from BC. They were refused registration many, many times without understanding why. And yet the Haida Nation, we voted a law on Haida Nation not so long ago. The Haida Nation recognizes Nadia, not only the Haida Nation, but also the Haida Nation in Alaska, because obviously this tribe doesn't have the same understanding of borders. So Nadia and her daughter are both members of the Eagle Clan, as recognized by the Old Masset Village Council. S-2 could allow Nadia and her daughter to be recognized, She received a letter from the government that said, no, you're not recognized, you're not Indigenous, etc. Imagine the impact on her to receive such a letter, and other people as well. Imagine the impact on other people who receive such letters, to see that they are not allowed to be part of their own culture. It's tough, but this is the reality. I hope that in our discussions and debates and in our study, if this is sent to committee, the bill will be that we will be able to return dignity to these people. I've also thought, all right, I can't just give up. This is urgent. There's currently a case in BC. We're waiting to see what is happening here before proceeding with the case. This here is a bill in itself, but the promise that I've made to my children and as a former commissioner is that we need to be self-determinant. We need to be able to decide these matters. But in the meantime, had I not walked for my son in 2010, there was no choice. So today, there is the possibility to register or not. My son has that option. And I say to my son, if ever we sign a law on government, an agreement rather on independence or self-determination, you will no longer be in. This is one step forward then. That many others have considered before and have many others blazed the trail for us. I hope that you'll be walking alongside us. And this was done with much love towards our families. We just want equality, nothing more. What should be corrected here is an injustice that never, ever should have existed. So this bill is a form of reparation. When I was 27, I came here to Ottawa and I said, one day I will be in the Senate if I can, and I will change the world. I was already old at the time. I said at the beginning
that we will have a First Nation minister, AU, she's Cree, who is sponsoring this bill, and the Innu senatrice, who is trying to sponsor this bill. And yes, I think we know what we're talking about. And yes, we know it doesn't go far enough. But yes, we know it's urgent. We know that. Two women, two different stories, but the same willingness of equity, equality, and, of course, giving back what was taken away from us. So we need courage to stand. I have that. Sometimes I don't, but I'm human. But I hope that we will do this change together. And the debate is important, and we need to hear the concern, but I do support the bill the way it is. And if we can make it better, of course I'll be happy. But it's going to be a conversation that needs to happen. Merci beaucoup.
Sénatrice Mention, voulez-vous...
Senator Mention, did you want to ask a question? Yes. Senator Audette, would you take a question? Let me first congratulate you for the language that you chose to speak in your speech. Congratulations. I'd also like to thank you for your pedagogical approach, which you use to help us understand what the situation is and fully understand. What I'd like to know with C2, will it solve the problem, or is there still more to be done? Senator Audette. Thank you and congratulations for your new role, Senator. There's still a lot to be done. And the list is repeated time and again. Every time we receive a new court ruling, the briefs repeat the same message. The Convention on the Elimination of Discrimination towards Women at the UN has mentioned what is happening here, the continued discrimination here in Canada, and the obligation to recognize paternity isn't clear. 6.1 and 6.2 isn't clear either. That's still unfair. If you like, I can send you a detailed list and briefs that you can read to learn more.
Mention.
Senator Mention, I have a supplementary question on that portion. When you say that there are several things that remain unclear when it comes to the law, are these things that can be amended, or would you prefer that the bill be adopted as in its current form, and so that the work can then continue and bring improvements over time? Senator Audette. Thank you. Not being a jurist, nor a lawyer, I'm going to answer you on the basis of my feelings. The fact that the British Columbia Court agreed to pause the case in the Nicholas versus the Crown. I don't have an official response, but my concern is that the person in question for this case, if they refuse the extension so that we can do our work as legislators, I think only the people in British Columbia can be re-registered in their natal land, because it is now before a British Columbia court, whereas there are people across the whole country who are affected by this and will be affected by the case. I think, apparently, from what I understand, we'll have to go before each provincial court and start all over again, and that may harm many people. Senator Brazeau, would you take another question, please? Thank you. So congratulations for your speech and for sponsoring this bill. I know it's important to do so when we're here and we have the opportunity to do so. My question is quite simple, and you may not have the answer, but it's a question to provide a little more context over this whole issue. You mentioned changes in 1985, and that's how I obtained my status. For a part of my life, I wasn't an Indian, and all of a sudden, I became an Indian. And then there were changes in 2011, 2018, and now. I was 10 in 1985. So I've been aware of this file for 40 years. So though I'm still fairly young, I've still been on this file for a long time. I think it's important for all of our colleagues here to know that this isn't about the federal government being bountiful, no matter who puts these bills forward. Because in 1985, as First Nations, we heard at that time, since we had denounced all of the discriminatory effects of the Indian Act, and we were told, oh, just wait, it will come. All right, so from 1985 to 2011, a fair bit of time went by. We waited. In 2011, we were told, we know there still remains discriminatory practices, but things will get better, etc. And here we are now in 2025. Often, when government respond in this manner, it's often because they've lost before the courts. If they lost before the courts, that means they used taxpayer money to fight against our rights. So, could the department provide us with a number as to how much money the federal government has spent since 1985 to fight status-related cases? Senator Audette. Yes, I will make the request. I hope that we will be heard and that they hear the question, because it's an important question. As you said, I do not know the answer, but we do wonder and have asked ourselves that very same question for some time now. Thank you for the question. Senator Brazeau, I have a little follow-up question. I've been here for some time, as I was saying, and perhaps you will obtain the answer, but do you know, are you able to discover, have you ever heard what the definition or the criteria that the Department of Indian Affairs, because it's the Minister of Indian Affairs who decides who's an Indian in this country and who is not, still today in 2025, have you ever seen the definition that the Indian Affairs Minister uses to decide who's an Indian in this country and who's not? Senator Audette. Thank you, Mr. Speaker. That question was asked. We meet with people from the department, and I'm waiting to see how things are done, and the training as well, because I'm told that there are friendship centres, women's group, Indigenous organizations across Canada who now have the mandate, though they have to be certified, accredited, and trained, in order to help people fill out their registration demands. So there are criteria. That means there are criteria. There are definitions. We'll have to see. Now, this is my own interpretation, once again, that there is a fairly impressive discretionary margin here. So those are legitimate questions, in my opinion, and they deserve an answer. And they will have to answer them.
Yes, I actually have one question before I take adjournment. Senator Audette, I was not at the technical briefing, but my staff was, and based on his notes, there's one question I have regarding the consultations that have taken place. The officials were saying they were in the process of, and that they reported receiving 60 distinct proposals from 80 Indigenous groups, which are currently under review to inform a long-term legislative solution. So I just wondered, has there been enough? Is this ongoing? Should we be concerned about whether or not consultations broadly have taken place, and if they're being informed and they're still working on it, it seems a little bit backwards. So I was just curious about your satisfaction with the consultation process.
Sénatrice Audette.
Merci beaucoup. I am not satisfied.
Senator Audette, thank you very much.
I didn't read. When I raised my hand for this bill, I had the next day a meeting with the official, a good conversation, frank and honest. I was told that there is some briefing or position paper or documentation that is coming from grassroots or organization. I'm still waiting for the list of who are they and what are their recommendation or suggestion. But we did emphasize that maybe it's not the approach of what's the most popular should be approach, but to make sure that it do reflect or respond to the need the change that we need to have. Okay, so I didn't see the brief, the documents, or the position paper, so I hope I'll get it. And it's gonna come. It's gonna come. I'm here. and I'm not going to give up.